I'm going to start talking, and everybody who's streaming out will regret their choices. First of all, yes, I'm Digital Rights Ireland's lawyer. I do some consultancy work. I'm a practicing solicitor in Ireland. One of the things that I thought I might be able to help with here is that GDPR is a kind of a sensitive topic in companies, and it's one of those areas where companies don't like other people knowing how things are going inside. And so I've been through the insides and then out again of quite a number of companies. I've got a kind of a sense of where everybody is. And maybe to give you a sense of where your company is in respect of everybody else, and also what you might expect to come next. Some blah, blah, blah. The GDPR, it's a law. You are still not finished writing it, basically, and we're still working on the policy definitions. In case nobody's told you, GDPR probably applies to your company, and if your company thinks it doesn't apply to your company or any part thereof, they're probably wrong. That is boring. There we go. Now, so here we are, and where are we up to now? Your organization probably has some sort of data register that they point to if anybody comes around to look at the data register. That data register probably is a bit iffy, but people are still working hard on it. There's something there. You probably have tons of policy documentation, because you can buy that. So you probably have loads and loads of policies where everybody knows, yes, absolutely, we have a shredding machine over there. We shred every 25 minutes. We have a coffee machine over there where we no longer use our fingerprints to access the cappuccinos, that kind of thing. And there's also some sort of sense that you've been on, maybe nobody has been on training yet, but there's a promise of training in the future where everybody will learn that GDPR is wholesome. And of course, you'll have updated your privacy policy, which is the most important part of GDPR. As anyone who lived through May 2018 will tell forevermore. But really what I'm hoping, well, I'm hoping this will work, are we done? So that's a Trudon. I picked the Trudon because it was the smartest dinosaur in all likelihood that they've found to date. It's glad to be able to get back to its job of killing probably iguanodons. And it thinks that the time has passed for it to worry about all that GDPR nonsense. And yet at the same time, there is a very large ball of light in the sky. And as you can see, this Trudon here up on top of the iguanodon, as it's gouging the flesh, is thinking to itself, is that ball of light bigger than it was 20 minutes ago? Now, being a dinosaur, it doesn't have great of a conception of time, but we're better than them because we know what's coming next. So the truth is that, in fact, GDPR, although it's come into force, we haven't actually seen it happening yet. So between now and Christmas, we can expect to see lots of excitement. This is something that's going to be happening. And I'm going to talk about a couple of these things. These are only just bullet points, but I'm not very good at slides. So I'm actually mostly going to be talking to you, and these are just to remind me what it is, not to forget. So look, between now and Christmas, the chickens are going to come home to roost in respect of GDPR for the first stage, because the regulators are going to realize we have to do something. We've got all this machinery. It really was quite an effort in order to build the machinery. And one of the strange things about legislation is once you build laws and give creatures powers, state entities, regulators, they kind of want to use them. Like, they really want to use them. I mean, they've been given extra staff. Budgets have been doubled. You know, somebody's going to want to know what's happening with all that stuff. And so we're probably likely to see the start of fairly heavy enforcement action. I mean, the thing came in at the end of May, then it's June, July, where everybody's trying to find their feet and tie their shoelaces. Then it's August, and Europe goes to sleep. And then September, we'll start to wake up again, and then October is when things will start happening. For example, the courts will open. So one of the things that we're looking at is, first of all, as you see, there's an extinction event likely to occur before the CJEU in relation to the Privacy Shield. There are two challenges heading towards the CJEU at the moment in respect to the Privacy Shield. There's one in Ireland, That's the latest iteration of Max Schrems' complaint in respect of Facebook, which got very exciting because originally it was only a challenge to standard contract clauses, and it had been carefully drafted in such a way that the Data Protection Commissioner didn't challenge the Privacy Shield, which was great up until the end of the case's hearing, where the lawyers for Facebook suddenly started talking about Privacy Shield. The judge got excited and Privacy Shield got bundled in, and it wouldn't otherwise have happened. As a result, there's now a challenge to the actual functioning Privacy Shield instead of the sort of academically interesting standard contract clauses method of transfer of data between the US and the EU. If you're relying on Privacy Shield to transfer data across the Atlantic, you've a couple of months to think about, is that a good idea? And if you think maybe there's a chance, telling you by the way, there is a chance, that Privacy Shield isn't going to survive to Christmas, then I think you should probably already be thinking about what you're going to use to replace it in order to legally justify those transfers. Otherwise, they're going to wink out because CJEU decisions are immediately effective. And like Safe Harbor before it, there won't be a legal basis for the transfers unless you've already put what's needed in place. And by and large, what's needed in place are what's known as standard contract clauses. I know you don't have to write the contracts. Nobody in this room is in charge of the contracts. And yet, at the same time, you're in charge of moving the data. And when they go around looking for which Volkswagen engineer is the person who did the bad thing, it's just one of those things that perhaps the people in charge of moving the data should make sure that they're not the people that the fickle finger of fate finally lands upon. Okay, so that's the Privacy Shield and transfers. We also have civil actions. Civil actions are kind of the dog that didn't bark in the preparations for the GDPR. Everybody was worrying about the fines. I put the fines literally as the last line on this presentation because I don't think it's particularly interesting. So the fines were 4% of your global turnover, and that was kind of scary because it was a set figure and you knew what it was because you could look and see what your global turnover was, and you could do a sum, and everybody likes doing a sum, and then they get 4% bracket. Lawyers don't like doing sums. So as a result, you got this kind of feeling that 4% was the key issue that we should worry about. In fact, it's not. The most significant thing that is going to happen is the commencement of civil actions from aggrieved EU users. These are people who can sue for compensation if they find that there's a problem. And there's no doubt about it that, as the history of the entirety of tort law demonstrates, it is the threat of civil action and payment of compensation on a mass basis which has the greatest impact in culture changes in any organization or industry. That's the reason why people on building sites now wear hard hats. That's the reason why we no longer send Harold Lloyd up the outside of the building without scaffolding, than that there are nice nets to catch you when you fall in Hollywood as an actor. Health and safety legislation was introduced to protect workers. It then became more expensive to hurt them than it was to treat them right. And so people, for economic reasons, decided we should stop killing our workers. Similarly, as a result of the civil actions here, it will become more expensive to misuse people's data than the potential profit from using it in an inappropriate manner. That is a piece of financial calculus which has not existed before now. I think it's pretty clear that it's very profitable to misuse people's data, and that the risk of a financial loss commensurate to that profit has never really been there in order to provide a financial incentive. Civil actions will change that. I invite you to imagine, let's say 1 million people, and each one of the 1 million people are awarded what the going rate is in the UK. The going rate for a pure breach, this is a breach solely in respect of their rights, but with no loss. They weren't harmed, they didn't lose any money, nothing else happened to them. They just had a fundamental rights breach. Currently, the going rate per one of those, per person, is £10,000 sterling, or approximately 15,000 euros in Ireland. Multiply that up by a number of, well, even 100,000, it gets kind of large. Hit 1 million, it gets kind of painful. these things sort of start to snowball up. And the difficulty is that unlike harming workers, where it's kind of difficult to simultaneously kill 100,000 workers due to a lack of hard hats, unless you're really Elon Musk, I suppose you could think of a way. But unless you're really dedicated to it, it's hard to do that kind of harm en masse at once. It's remarkably easy to make that kind of error in respect of people when you're handling their data en masse. So that's one of the risks that we're going to see starting to crystallize. There are 2 already filed, and they're heading towards the courts. Max Schrems's None of Your Business organization and France's French organization. I did German school. Apologies. And those are inside the EU. And if you're thinking about civil actions, you're probably thinking to yourself, oh, yes, so those are inside the EU. And then there's all the people outside the EU. And actually, there are lots of those, like loads. And many, many, many of them have now got the benefit of the GDPR due to this slide that I skipped past there. Because you'll notice that anyone, anywhere established in an EU member state, including the data of non-EU residents, and not citizens, residents is the relevant policy. So what we have is we have an awful lot of people who are established. This fallen asleep. We have an awful lot of people who are established, and they're processing data, and that data can be of places all over the world. And all of those people have a right to take an action if their GDPR rights have been breached. Now, unlike all the people in the EU, they don't get a choice of going to their local regulator and making a complaint or lodging their claim in their local court, because they don't have a local court that handles GDPR. As a result, the entire planet outside the EU has only one jurisdiction it can go to, and mostly Ireland, in fact, is that jurisdiction. So, the Irish courts are going to be busy. There's a shortage of Irish judges at the moment. I believe there will be a shortage of Irish judges in the coming year or 18 months or so. And I've already had a conversation with the Chief Registrar of the High Court in Ireland, and they've confirmed that they will start accepting mass plenary summonses. So you could put, say, 1 million plaintiffs on a single docket. This is a way around the fact that Ireland has no method of providing for class actions. And the only alternative is to launch 1 million individual cases with 1 million individual sets of legal costs. So, given all the choices, they've decided probably allowing 1 million on a docket is probably the best they can manage. Though they have promised to hand type them all in, which I think is worthy of some looking again, but nonetheless. We suggested we go on a USB stick, but they said, no, we like it on paper. That's how we've always done it. Who am I to argue? Now, what does that mean? Well, look, some of you work for very clever organizations, fierce clever altogether, and they're riddled with good thinking. And they thought to themselves, what if the GDPR just didn't apply to all the people outside the EU? That would be much better. And so some of the clever organizations filled with the best and brightest changed the wording of their terms and conditions. And now, due to the magic of terms and conditions, they will tell you that the GDPR isn't applying to all the people outside the EU. Now, regrettably, this is hooey. Regrettably, because it would be lovely if you could just magic away the things. But in general, none of this limitation, this effort of trying to remove people from the net of the GDPR functions as long as people inside Europe are still, friends with people outside Europe, and therefore those people outside Europe still have their data being processed in Europe, looking at no visaged homes in particular. These are the kinds of changes that you make on a sweaty 24th of May when you realize that there are some of the things that you might not have thought about are suddenly popping up. This is an awful lot of sticking plaster, and you remember our IFI data register. I can assure you that if your company has a data register, it is iffy, because bluntly, all the data registers are iffy. Now, you're all right, because, you know, there is safety in numbers. If you were the only company with an iffy data register, you'd probably be more concerned. The problem is that from a regulatory point of view, it does make it easy to come and find a problem. And again, no one wants to be the Volkswagen engineer who's in charge of the iffy line in the data registry. I'm going to show this just as a helpful reminder. These are all the bases that you can process data under. And in a lot of cases, you're probably relying, you plural, are probably relying upon consent, the best of all bases. But the problem is that as the data protection regulators have sort of been shaking themselves into a new shape, that consent is becoming a much more complicated thing than click OK. We're definitely seeing, I mean, they're working currently on a policy definition in respect of consent, taking into account, what would we call those user interfaces where you click OK? Cheats. We'd call them cheats. Because at the end of the terms and conditions and you've clicked OK, I mean, they're long, but they will tell you things. But if you've clicked OK and you don't know what you clicked OK to agree to, you haven't consented. I know there's a box that ticks that the user consented and it's ticked and, you know, everyone feels good. But the moment the user complains, I didn't know you were doing that with my data, everything falls apart. And by definition, all problems start, all complaints start with a user going, I didn't know you were doing that with my data, by definition. And so if your consent is too complicated to understand if you're a human being, or if your consent, or even a lawyer, I distinguish between those two parties, but that's only for the prejudices of the room, of course. If your consent is too complicated to understand, then probably you don't have consent, even if someone ticked the box. If your consent involved clicking OK or further details, what? No, wait, should that not be no? Yes, no? So say you click further details and then you get 32 things and it says, would you like to read our privacy policy? And you go into the privacy policy and it says, you know, you can reset your own cookies in your own browser. You didn't get consent. So all of these things which were designed to basically carry on eating iguanodons as before, because we didn't want to stop eating iguanodons, they're so lovely and tasty. The difficulty is that these things are reaching the end of their life. Now, I'm not saying that you have to solve all these problems. These look like somebody else's problems in the main. But I do know that if you're planning for the next year on carrying on the way things were, chewing on iguanodon, then I think you should pause and ask the people around you, are we chewing on iguanodons properly? Is this a good idea? I'm going to show you this one here. This is the entirety of Article 22 of the GDPR. Have a read, go on. It's only 3 lines. You can tell your friends you read law. Funny thing, that kind of happens sometimes. And the difficulty is that without consent or any of those other bases that we looked at, it's kind of illegal. And in fact, that's probably, this here slide is probably one of the reasons that I'm up on the stage on my own instead of being joined by anybody else who might have helped to sort of convert this into a more palatable format, because nobody wants to think about how this applies to many of their most cherished products and projects for the future. Automated processing kind of runs deep into the heart of many of the big sort of moonshot AI, machine learning, that kind of thing. This here, it looks like a spanner, doesn't it? It looks like a spanner in the machine. And so if you're going to have we're going to have automated processing, and you don't have consent, and you don't have any kind of legitimate interest, and you don't have a legal basis for doing it, and you don't have any of those lovely things that we showed you just there a second ago on a list, well, then what you're actually going to be looking at is you're going to be looking at an issue where you've built in illegality into the way that you process data, that you actually rely on illegal processing in order to be able to do your job. Don't do that. And if people are telling you to do that, tell them that they must stop. Because if they make you do it, somebody inside your organization is going to do this. This is the dramatic button press that doesn't work. I'll have to stand over here. There. So anytime any of those things happen, it's a data breach. So you're going to end up having to notify the data protection authority in your local area, whoever yours is established, or all of them if you didn't choose a single established area. And you're going to have to say, we've had a data breach. And if your data breach involves having fed 1.2 million, 5 million people into a machine, then you've had 5 million data breaches. And you've got to notify them within 72 hours of it having happened. There's an actual separate fine level for failure to do this at 2% of global turnover, or up to 20 million as opposed to 40 million. Or up to 10 million, I beg your pardon, as opposed to 20 million. You also have to find all of the 5 million people and let them know that there's been a data breach without undue delay. So not 72 hours, but they want to see you getting on it right away. And I mean, I've said happily, put a data breach plan in place now to use later, but this feels an awful lot like one of John's earlier plans for what happens when WhatsApp hits 20 billion users. We have difficulties in respect of putting together a data breach plan, which involves us trying to find all of our users and telling them that actually the entire thing that we do has been illegal and we've been doing it wrong. So let's not do it wrong. Now, one of the other things, the area where people are going to be protected here, this is the thing that should sound the alarm, is you're going to have a data protection impact assessment built into your system. Yes? Anyone? Hands up anyone who's done one of these yet. Funny. Nothing new has happened. Okay, 1, good work. 2, liars. So, it's good to hear that nothing new has happened in the field of data processing since the 25th of May. Because if anything new had happened, everybody here in this room would have had to do a data protection impact assessment. You've got to do one under Article 35. And as a result, you would all have gone through a process where you consider what are the data protection impact of what we're planning to do. And you've worked out, actually, I think this is a good idea. And here are our justifications for it, and here's the reason it's legal, and therefore, as a result, we can go ahead and do it. And you've got that on a sheet of paper, and you put it in a drawer, and if anyone ever challenges you, you produce it, and you are not working as the Volkswagen engineer. However, if you do the process, and you get to the end, and you discover that actually the great idea that somebody's come to you and said, we want to implement this, involves breaching 5 million or 10 million people's data, and it's not worth it, and there isn't a legal basis for it, then you probably will have a sheet of paper that says, let's not do that. And if you don't have a system that allows you to stop and say, let's not do that, you probably don't have a DPO who is required to be consulted on every one of these data protection impact assessments. You don't have a DPO who has enough power. Data protection officers, doink. I feel like my granny trying to work the remote on the, here we go. Now, I've put in, this is very unusual, there we go. So people who absolutely have to have a DPO are those regularly processing large amounts of personal data, or those processing sensitive personal data at some scale. I don't think I have to go beyond that in this room anyway. And maybe you need to hire one, and that's tough. And the reason for that is here. This is the Article 29 Working Parties Guidelines on Data Protection Officers. And they've got a quote, which it's worth producing, even though it is kind of wordy. And they say people who should not be data protection officers. And those people are people who can make decisions. No senior managers can be a data protection officer. Chief executive, chief medical officer, head of marketing, head of human resources, head of IT, but also not the people who represent you in courts, so not your lawyer. You'll realize that, of course, that the number of available people, once you've taken all these people out to do the job as a second job, to wear as a second hat, it kind of, the pool is diminished. And so as a result, I don't want to do that. And I would suggest that perhaps considering an external DPO might be one of the things to do, but then I would say that, wouldn't I, as I offer external DPOs. But in reality, the issue here is not who's going to be the DPO, but whether they've been empowered. Because your best protection in ensuring that you're not the true Don who gets hit by the comet, your best protection is to ensure that your DPO is an empowered DPO and that you can go to them and say, they're trying to make me do things and I think they're wrong. What do you think? And if the DPO says, yes, those are wrong, that they have the power to go and you don't have to say stop. They're the people who are able to say stop. Now, normally I end here and I say any questions and I throw it out to the room and we have lots of questions. But I'm not going to do that because the screen says 1 minute, and also because, and that would be a short question, but also because I'm doing a workshop tomorrow. Last time I did this, it ran for 3 hours, so I am confident that if you have any questions related to GDPR, that you will have an opportunity to put them to me then, and I will answer them. And I promise you that my workshop tomorrow, although it did last 3 hours last time, I only planned for it to last an hour and a half, and so I do answer all the questions, and nobody records the questions being asked. So unlike this format, which is probably useful for people to bring out their dead, and we lay them down in front of us and try and work out what we can do to, if not bring them back to life, then at least bury the corpse with dignity. Thank you very much.